Washington, D.C. has one of the most restrictive rent increase frameworks in the entire country. And if you own rental property in the district, you need to understand these rules inside and out, because violating them can result in serious penalties, tenant lawsuits, and regulatory action. The governing law is the D.C. Rental Housing Act of 1985, D.C. Code Title 42, Chapter 35, administered by the Rent Administrator and the Rental Accommodations Division within the Department of Housing and Community Development. The first thing every D.C. landlord needs to understand is that the district has rent stabilization, commonly called rent control, and it covers the vast majority of residential rental units in the city. If your property was built before 1976 and is not otherwise exempt, it is almost certainly covered by rent stabilization. The exemptions are narrow. They include buildings owned by a natural person who owns no more than 4 rental units in the district, newly constructed buildings for the first 15 years, and federally or district-subsidized units where the subsidy already controls the rent. Outside of these limited exemptions, rent control applies. For rent-stabilized units, which again is the majority of rental housing in D.C., the landlord cannot simply raise the rent by whatever amount they want. The maximum annual rent increase is limited by a formula tied to the Consumer Price Index. Specifically, the maximum allowable increase is the CPI percentage increase plus 2%. And even with that formula, the total increase cannot exceed 10% in a single year. So if the CPI increased by 3%, the maximum rent increase would be 5%, 3% plus 2%. And even if the CPI increased dramatically, the 10% cap applies. For elderly tenants and tenants with disabilities, the restrictions are even tighter. The maximum allowable rent increase for these protected tenants is limited to the CPI increase only, without the additional 2%. So if the CPI increased by 3%, the maximum increase for elderly and disabled tenants would be 3%, not 5%. This additional protection recognizes that elderly and disabled tenants on fixed incomes are particularly vulnerable to housing cost increases. Before implementing any rent increase on a rent-stabilized unit, the landlord must file a notice with the rent administrator. The landlord must provide the tenant with at least 30 days written notice before the increase takes effect. The notice must specify the current rent, the new rent, the percentage of the increase, and the effective date. The notice must also inform the tenant of their right to challenge the increase with the rent administrator if they believe it exceeds the allowable maximum or was improperly calculated. Here's where DC's framework gets even more detailed. The landlord can only implement one rent increase per 12-month period for each unit. You cannot raise the rent twice in the same year, even if both increases fall within the CPI plus 2 formula. And you cannot raise the rent during the first 12 months of a new tenancy. The tenant is entitled to at least 1 year at the initial rental rate before any increase takes effect. DC also has specific rules about when rent increases can be implemented relative to building inspections. The landlord must have a current, valid basic business license to operate the rental property. If the building has been cited for housing code violations, the rent administrator may deny or delay the rent increase until the violations are corrected. This ties rent increase authority directly to property maintenance. Landlords who don't maintain their buildings can lose the ability to raise rent. Now let's talk about the types of rent increases beyond the standard annual adjustment. DC allows several categories of additional increases, but each has its own requirements and limitations. Hardship petitions allow landlords to seek increases above the standard CPI plus 2 formula if they can demonstrate that the property's operating expenses, including taxes, insurance, maintenance, and debt service, have increased to the point where the current rent levels don't generate a fair rate of return. The landlord must file a detailed petition with the rent administrator, including financial documentation. The rent administrator reviews the petition and determines whether the additional increase is justified. Tenants have the right to contest the petition and present their own evidence. Hardship petitions are complex, time-consuming, and require substantial financial documentation. They're not a casual process. Capital improvement petitions allow landlords to pass through the cost of significant building improvements to tenants in the form of rent increases. The improvement must be a genuine capital expenditure, not routine maintenance, and the landlord must file a petition with the rent administrator documenting the improvement and its cost. The increase is typically amortized over the useful life of the improvement, and the monthly increase is calculated based on the tenant's proportionate share of the total cost. Tenants can challenge the petition if they believe the improvement wasn't necessary, the cost was inflated, or the calculation is incorrect. Substantial rehabilitation petitions allow landlords who have performed extensive renovation of a building to seek larger rent increases. This requires a showing that the rehabilitation substantially improved the building's condition and that the cost was significant relative to the building's value. The requirements for these petitions are rigorous, and the rent administrator carefully evaluates whether the rehabilitation justifies the proposed increase. Voluntary agreement increases are available when at least 70% of the tenants in a building voluntarily agree to a rent increase, typically in exchange for the landlord agreeing to make specific improvements or provide additional services. These agreements must be submitted to the rent administrator and must demonstrate that the tenants genuinely consented without coercion. Now let's address what happens when a unit is vacated. DC has a vacancy adjustment provision that allows the landlord to increase the rent when a unit is voluntarily vacated by the tenant. Under DC law, when a tenant voluntarily vacates, meaning they choose to leave, not that they were evicted or forced out, the landlord can increase the rent by up to 10%. This vacancy increase can be taken in addition to the standard annual CPI-based increase. However, and this is critical, the vacancy increase is limited to 10%. DC eliminated unlimited vacancy decontrol in the 2006 amendments to the Rental Housing Act. This means that even when a unit turns over, the landlord cannot reset the rent to market rate the way landlords in some other rent-controlled jurisdictions can. This limitation on vacancy increases is one of the most significant aspects of DC's rent control framework. In cities like New York, before recent reforms, landlords could substantially increase the rent when a unit was vacated, which over time eroded the effectiveness of rent stabilization. DC's 10% cap on vacancy increases means that rent-stabilized units remain relatively affordable even as they turn over between tenants. For units that are exempt from rent control, including those in buildings constructed after 1975, owner-occupied buildings with 4 or fewer units, and units in their initial 15-year exemption period, the landlord can set the rent at any amount the market will bear. There's no CPI cap, no rent administrator filing requirement, and no limit on the frequency of increases for exempt units. However, the landlord must still comply with the notice requirements, at least 30 days written notice before any rent increase takes effect, regardless of whether the unit is rent stabilized or exempt. DC also imposes specific requirements on how rent increases are communicated. The notice must be in writing, must be served personally or by certified mail, and must include all the information required by the statute and regulations. Oral notices or informal communications about rent increases are not sufficient, and the notice must be provided in the language in which the lease was negotiated if the tenant has limited English proficiency, a requirement that reflects DC's diverse population. Tenants who believe a rent increase is illegal because it exceeds the allowable maximum, was not properly noticed, or violates other provisions of the Rental Housing Act, can file a complaint with the rent administrator. The tenant can also file a tenant petition challenging the increase and requesting a hearing. During the pendency of the petition, the tenant may be required to pay the increased rent into escrow, but the increase is not considered final until the rent administrator resolves the dispute. The rent administrator has the authority to investigate complaints, hold hearings, and issue decisions ordering landlords to roll back illegal increases and provide refunds to affected tenants. If the landlord knowingly charged rent above the legal maximum, the penalties can be significant, including treble damages in some circumstances. The Rental Housing Commission serves as the appellate body for rent administrator decisions, and either party can appeal an adverse ruling. DC also prohibits rent increases that are retaliatory. If a landlord raises the rent in response to a tenant exercising their legal rights, such as filing a habitability complaint, reporting code violations, or organizing with other tenants, the increase can be challenged as retaliatory. DC's strong anti-retaliation protections apply to rent increases just as they apply to eviction actions. One practical consideration for DC landlords: the administrative requirements of the rent stabilization program are substantial. Landlords must register their rental properties with the Rental Accommodations Division, must maintain accurate records of all rent levels and increases, must file the appropriate forms with the rent administrator before implementing increases, and must respond to tenant petitions and complaints within specified timeframes. Failure to register the property or maintain proper records can result in the landlord losing the right to collect rent increases, even increases that would otherwise be legal under the CPI formula. DC's rent stabilization program also requires landlords to provide tenants with certain disclosures at the beginning of the tenancy. The landlord must inform the tenant of their rights under the Rental Housing Act, must disclose whether the unit is covered by rent stabilization, and must provide the current and maximum allowable rent for the unit. Failure to make these disclosures can affect the landlord's ability to enforce rent increases later. For landlords who believe that rent stabilization doesn't apply to their property because of a construction date exemption, an owner-occupied exemption, or another qualifying exemption, it's essential to confirm the exemption with the Rental Accommodations Division. Claiming an exemption that doesn't actually apply and charging above-market rent can result in significant liability, including the obligation to refund all overcharges plus penalties. Getting an official determination of your property's status is a wise investment. The bottom line for DC landlords is that rent increases require planning, paperwork, and patience. You must know whether your unit is covered by rent stabilization. You must calculate the allowable increase correctly using the current CPI data. You must file the required notices with the rent administrator. You must provide proper written notice to the tenant. And you must be prepared to justify the increase if the tenant challenges it. The system is designed to protect tenants from excessive increases while allowing landlords a reasonable return. But only landlords who follow the rules get the benefit of that balance. For the complete guide to Washington, D.C. rent increase laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel so you stay current on every landlord-tenant law that affects your business.